My name is Teresa McKee. I am the CEO for the Nevada Realtors. And thank you for joining us for the second Eviction Moratorium webinar. We had one a couple of weeks ago that was attended by about 120 of you, and we're far surpassing that with our second one here. I want to thank BOMA, the organization put out this invitation to their membership, and it's more on the commercial side, but this does affect both commercial and residential, and we hope to get to everybody's questions. If you do have questions, go to the chat room, and we will be monitoring that to answer your questions. Those of you who sent in questions initially, we have those, and we've tried to organize them so that hopefully we cover everybody's question. If for some reason you have a question that is not answered, if you're a Realtor member, you can call the legal information line, and that number is 800-748-6999, although you will be asked to send an email to infoline@nvrealtors.org, and we'll put those both up in the chat room as well. We're very fortunate to have some great minds with us today to answer your questions. We've invited two judges, Judge Saragosa and Judge Hashchef, one from the north, one from the south. We're currently waiting on Judge Saragosa, and Judge Hashchef, of course, as things happen in today's crazy world, his calendar in the court has run long, and we're not sure he'll be able to join us. We also have guests from the Attorney General's office to answer the questions that might be appropriate for them. But what I want to do first while we're waiting is open a poll. And so Dan, if you want to open the first poll, we want to get a feeling from you all on both the residential side and the commercial side, what your deficiency rate is currently, what the percentage of the people that are behind on their rents currently is. So Dan, if you can put up the first poll. I don't know if we'll be able to see it as panelists. Dan, is first poll up? Okay, it looks like it's up. I can't see it, but
Teresa, if you hit polling, it might pop back up because mine went down and then I hit polling at the bottom.
I don't have a bottom. Mine's all at the top.
Okay.
So Tiffany, let me know if you see that it looks like a lot of responses are up. And then we'll have another one for commercial. And I think Molly, you wanted to make some comments on this poll as well.
Yeah, so thank you, Teresa, and thank you for everybody for joining. We've got over 200 participants, which is fabulous. That just tells you how important this topic is. And thank you guys for the first webinar. Good morning, Judge Saragosa. Thanks for joining us today. But after I watched the first webinar, I unfortunately wasn't able to watch it live, and I watched it afterwards. I have been involved in this PAG since March, and I had more questions. So I know we all have a lot of questions regarding what's going on between the CARES Act and the governor's directive. And so the poll today is fabulous. It's a snapshot in time, but as I've been discussing with a lot of the members of our company and with Teresa and everybody on the call here today, it really is a snapshot in time. It's most people that we've spoken with, or it's under 10%. But as the country continues to have an impact from the pandemic, we fully expect that this is going to go longer than just today, longer than the August 1st date and the September 1st dates that are going to open up for other actions in terms of evictions and moratoriums and whatnot. And so we just ask that you stay very well connected, always be informed, definitely reach out to the state and the local people for more and more information, but we're all going to need to work together through this. It's going to take a lot of empathy, a lot of understanding, and if you look at the last 120 days, we've had 132,000 deaths in America, and millions have lost their jobs. So this isn't something that we're going to deal with just today, or that we thought that we'd be through it in 60 days. We're at 120 days now, and we fully believe that we're in it for the rest of this year. Most indicators show that we're going to be in this position for quite some time. So let's lead with empathy, let's lead with information, and make sure that we are advocating for our clients, but also keeping in mind that, that we're all in this together.
Thanks, Molly. Those are great words, and we appreciate that. We're going to close that poll now and open one that has to do with commercial. So anybody who practices on the commercial side, if you can enter your information there as well. And while people are doing that, then I want to, of course, you've heard from Molly already. Molly Hamrick from Coldwell Banker is the chair of our PAG. Fantastic, very knowledgeable property manager, has led our property management presidential advisory group in a myriad of duties and issues during the past 3 or 4 months. And one of the results is coming up with these webinars. We have worked with the Attorney General's office and the judges to come up with solutions to this crisis, and we're part of the eviction moratorium directives that the governor issued, and that's why we're here. We're here to now make us all better by educating all property managers, whether they're Nevada Realtors members or not. All are welcome, and we invite all questions. So Molly, I will turn it over to you now. Thank you very much.
Thank you, and thank you for your introduction, and good morning to everybody. So I just want to briefly just step back real quick and give a little bit of history on how we got here and where we started. So as many of you are well aware, in March when the pandemic really hit hard and the governor's directives came out and the CARES Act came out, I reached out to our state president, Chris Bishop. He loves to hear from me because I'm always calling him on things and saying, what are we going to do about this and what are we going to do about that? And Chris reminded me that most of our documents, well, all of our documents are driven by our local associations and not by the state. And I said, well, that's nonsense because this is a state issue. And so he said, I think you're right. And why don't you chair a PAG and get out in front of this? And so be careful what you complain about because you'll become chairing that initiative, which has been in the beginning. I was a little nervous about it, but it's been very informative. And we've had a lot of great people on our PAG. And so we've been working hard since March, since this came out, to try and get in front of all the different directives and moratoriums, whether they're national or locally or state driven, to ensure that everybody is informed, that we're making and helping our clients make the best choices and decisions based on what really is existing right now. Because I don't know about you, but I'm not a lawyer, and trying to understand everything that 800-page CARES Act, as well as the governor directive and how that applies towards our business, has been very difficult. And so hopefully we're providing some guidance for you all and helping you better understand what that looks like. As chair of the PAG, I was able to work with, thank God, Judge Saragosa jumped on from the very, very beginning. So we appreciate all her efforts. She's been on since day one. And then Judge Haschef joined us later as well. And so we've had their insights, because what we do on a daily basis, and especially when it comes to evictions and asking for the courts to rule, we need to understand what they need from us in order to be fair to all parties and to make sure that we don't have glitches. Because if you show up and you don't have the proper documents, haven't done what you're supposed to do, then you're going to start the process all over again. That's going to frustrate your clients and the court system as well. And so we worked very, very hard over the last 4 months with people from the local associations, both in the North and the South. We've all worked together. And we've also worked with legal aid and the AG's office and some of the other associations like the apartment association. So this started out very small and it got really big really fast. And we knew it was very important that we all worked together because it's affecting hundreds of thousands of people from all over the state. And so that was really the genesis of all of our meetings. There was a lot of discussion on backed rents, on again, all the different things in the CARES Act and the moratorium. What came out from that were a couple of documents that I hope you all have had a chance to review. I know that our local president, Tom Blanchard, and myself did a quick, I don't know how quick, maybe it was 10 or 15 minutes webinar. And when we pushed out the new documents that came out from our group, and that were also adopted by the AG's office, which was really, really exciting for us, because again, it's not a mandatory document, but it provides a statewide guidance on how we can work with the back rents and the unpaid rents. And so during that process, we came out with the acknowledgement form, which works for both residential and residential sales for buyers and sellers, but it also works for our tenants and our landlords. And while it doesn't talk about rights, because again, from the National Association of Realtors, we realize that you can't really have clients waive their rights during the pandemic because it's really hard to track where the virus is coming from and how it's been affected and who's being affected and all that. And so what we really wanted to do is make sure that everybody acknowledged that this is happening, and that while conducting business, there are some risk involved in conducting real estate business, whether you're a buyer, a seller, or a tenant or a landlord. And so in doing that, we have the acknowledgement form, which is really very basic, but at least it puts in writing that we are all aware of the risk and that we're all doing our best to mitigate those risks. And so that's the acknowledgement form. And again, I encourage you to watch the quick webinar as to what that form is for and how we can use it.
Molly, if I could just jump in briefly, because Christal and I were actually discussing this yesterday. We've been getting a lot of calls about whether this COVID acknowledgement form is to be used along with the eviction moratorium, or if they're separate documents. And so we just wanted to make it clear that the COVID acknowledgement does not grant access to the tenant's property right now. So they're supposed to be used separately, and you can follow up with Christal. She has a wealth of knowledge on that, on the info line, or if you have anything else to add, but that document's not to be used along with the eviction moratorium.
No, and that's a great point, because we've had a lot of questions on that as well, as when can we get into tenant occupied properties? And that's completely separate. Again, it's just an acknowledgement that even tenants that are looking at properties and moving into properties still have some risk as well. So it really is just an acknowledgement. It's not a permission slip, so to speak. So good point. The other really great document that, again, is not mandatory, but highly, highly encouraged to use is the lease amendment for the rents that are in arrears. And it outlines very succinctly rents that were due pre the governor's directive in mid-March and rents that were due post, and how those are handled. And so again, if you've got any questions, I mean, we are all very fortunate. Bob said earlier in our company sales meeting today, we've never been more proud of our Nevada and our local association leadership. They have worked tirelessly during this pandemic. And when you talk about fatigue, just Zoom fatigue, just overall fatigue, people have worked nonstop to, again, assure us that we are able to move forward in our businesses and move forward in a very legal and distinct manner. So please make sure you're looking at those documents and using those documents. If you have any questions, the legal hotline, which is up in the chat, is always something you can reach out to. Plus, NVR has a great amount of resources on their website. I encourage you to go there and look at their website and download. There's things that you can send to your landlords. There's documents you can send to your tenants, to your sellers. I encourage you to do that. It's hard to articulate all the different things that are going on in today's world as it pertains to our owners and to our tenants. But when you push the FAQs out that have come out from NVR, it's very, very easy for our clients to understand them much better than us trying to explain them to them. So I highly encourage you to do that as well. I know Judge Saragosa is on the line with us, and so please make sure you're using the chat. We're going to try and do our very best to end by 11. We've got questions that were sent into our legal hotline already, so we're going to go over those questions for you all, and then also do our best to address the ones that are in the chat. If we do not get to every single question in the chat, please know that we will follow up with FAQs like that just came out yesterday from our very first property management webinar. We'll follow up again with those FAQs, and I see everybody shaking their head, so that we make sure that you guys get those questions answered as well. And I don't know about you, but I'm sure you'll have more questions after this is over. So please make sure you're pushing those forward as well, because they're super important. With that, Judge Saragosa, I thought I'd start with you because you're in the thick of it. And again, thank you so much for your time and all of your advice in moving forward and helping us adopt these new documents and best practices moving forward as the moratoriums start to get lifted and the either eviction, or what we're hoping happens more or less is that we're able to work out the arrears, those move forward. So I'll give you a few minutes to just talk about how you've gotten to this point as well with us, and then what you see moving forward, because as of recently, you've been able to see more and more processes take place. So with that said.
Well, I was invited to be involved, I guess, by Mark Kruger of the Attorney General's office, who was, I guess, shepherding this group that was trying to come up with a singular form that could be used to advance the governor's vision of encouraging landlords and tenants to come to an agreement to take care of their arrearages in the rent, rather than just jump to the eviction process. We all know that everybody has suffered due to this pandemic and the closure of our economy, and has taken a drastic toll on many. So Mark Kruger, being from the Attorney General's office, his area of expertise did not include landlord-tenant issues. So he needed somebody to kind of advise him on the court's process and the current statutes and how they interplayed with each other. You know, originally the original moratorium sent by the governor in Directive 8 was very broad and, you know, didn't distinguish between commercial or residential or mobile home parks. And there's a whole post foreclosure. We have a ton of different kinds of eviction type actions or unlawful detainer actions in our courts. So I was kind of brought in to advise him or educate him on kind of the background and the laws related to Chapter 40 and Chapter 118A, and to help. So that's kind of was my involvement. I've been involved in that. I've also been involved in many discussions with our Supreme Court, to include the Access to Justice Commission. And everybody has kind of this idea that they want to help, but sometimes, you know, it was best to have a singular group that was addressing the issue in a consistent way across the state. So that's where the lease addendum promissory note came from. The idea was to come up with a form that could both be used by a landlord while the lease was still in existence and while the tenant was still in the property, to come up with a manageable method agreeable to both parties to take care of rental arrearages. But it could also be used as what we call a condition or covenant of a lease, because it's a lease addendum, it becomes part of the lease, so that if it was not adhered to, there was some teeth to it, the landlord could then use the eviction process. But not only that, but once the lease is terminated, the promissory note portion of this document lives on. And so if many of you may have had a situation where your tenant owes money either in back rent or damages or whatever after the lease expires, and you know that going through the small claims process is also, you know, yet just another process in the court. So this promissory note, part of it, made that simplified, if you will, because the tenant already acknowledges in a written document the amount of the arrearages. At that point, it's just a matter of simple accounting for how much money came in and was put towards that balance due. It's a lot simpler to proceed in a small claims action for that money in the end than it is to try to prove it all up with your overall accounting of your rent and utilities and everything else that goes in your ledger. So that said, this should be a completely separate ledger that you are using. If you use the lease addendum promissory note, you are taking a chunk of money that's rental arrearages and you're setting it over here and you're accounting for it separately, similar to the way you would keep a separate ledger for HOA dues and then HOA fines. It must be accounted for separately. So don't confuse it with your regular monthly money coming in. I've often recommended that you put a different date for the payment date for a rental arrearage payment pursuant to the lease addendum than you do for your regular rent. That way you and your tenant can both keep it clear. If they come to you with money, you're going to know this is rental money for the first, and over here this is their rental arrearage money paid on the 15th or something like that. So that's just, I think, a helpful tip. Certainly not legal advice, just common sense that make it easy for both landlord and tenant.
And Judge Saragosa, if I could jump in, and the reason that that's also such a great practice is because the type of eviction or reason that you could file evictions will change. So for example, in July, if they come up with this agreement to pay an arrearage on August 5th, the first month of the arrearage, and they fail to make that payment, you cannot obviously file until September 1st, the non-payment of rent, but you could file a 5-day, and so breach of covenant. And so you just explain that, because it's a little bit, I think that's confusing, but it's that's the point of keeping those two balances and those two numbers separate.
Yes, Tiffany's 100% accurate. What I often say is, Chapter 40 is like your toolbox, and the various statutes within Chapter 40 are the various tools in your toolbox that you can use as a landlord when you are in need of an eviction or in need of recovering possession of property. So one of those tools is the 7-day pay or quit notice for non-payment of rent. That we all know, pursuant to the governor's directive, you cannot use until September 1st. But starting August 1st, there are all kinds of other tools that you can use. You can use the 3-day nuisance notice. You can use the 3-day waste notice. You can use the 5-day breach of covenant or condition of a lease agreement. And generally that would be something like, your lease agreement says the tenant's not allowed to have a pet and they have a dog, and you use a 5-day notice to say, hey, cure or leave in 5 days, get rid of the dog or leave. If they fail to do that, then you proceed with the second 5-day unlawful detainer notice. So in this situation, the lease addendum promissory note is taking that chunk of money of rental arrearages and it's setting it over into a different spot. It's still, yes, it was rent at one time, but as a landlord, you're waiving your right to proceed on non-payment of rent for that money in lieu of this payment plan. But what you're gaining is the ability to proceed by way of a breach of a lease covenant. That requires a 5-day notice. There's forms available on the Civil Law Self-Help Center website or on the court's website for that form. It's a 5-day notice to cure or vacate. That gives the tenant 5 days to cure that delinquency of that rental arrearage payment. If they fail to do so, you follow that up with a 5-day unlawful detainer and it proceeds to a summary eviction. That can begin August 1.
Thank you. We've been getting a lot of questions on that, so thank you.
And there's a lot of confusion, so we appreciate that. And again, to Judge Saragosa's point, the more that we can use what's in our toolbox and have it correctly done, the easier it will be for us all to move forward with whatever plan it is that the landlord and tenant work out. And so the rumors out there is there's going to be this onslaught of evictions and foreclosures and all this happening, and we're trying our best to get in front of it. It's in the best interest of everybody, including the landlord and the tenant and the property owners, is to work out these deals as best as possible. And then if the tenant were to default, then of course we've got those tools in our toolbox to move forward with. But so we appreciate again all the hard work that the AG's office, that our leadership has done, and that the judges have done to help us get this form designed in a way that works for all parties. And I also do believe that the judges will be familiar with this form, and they won't have to go and have to go backwards and track through to see what other forms are out there. And so it'll help the process move forward as well. The other piece that's really important is that affidavit that we sent out as well. That's in effect, obviously, just for another 10 days here, though. But with the CARES Act, there was an affidavit for properties that were underwritten by the government from the forbearance from evictions as well. And so we need to make sure that if you do bring something before the courts, that is filled out as well and completed, so that they know whether or not that's a property that is under the CARES Act forbearance. Super important. And you can find all those forms again with Nevada Legal as well. And so we've got a few other panelists with us today, and again, I had a group and still do have a great group of people that are on our PAG. And last time you got to meet Tom and Vandana and who else was on that call?
Ashley Hott.
Oh, Ashley course, she chaired that call. And so Danielle is here today, and I know that she's had a lot of questions come her way as well. And Danielle, do you want to share one of your top questions that we can get answered on this call today?
Sure, absolutely. Thanks, Molly. So one of the questions I've been getting a lot of is, if a tenant is in holdover status and a final walkthrough is scheduled during this time, can the buyer perform a final walkthrough?
Judge Saragosa, do you want to take that one?
It's my understanding that the restriction on going into the property was that you could not bring in a prospective buyer into an occupied premise. So if you have a tenant in property that's being sold, you still cannot bring a prospective buyer to go walk through that property. But in terms of you as the landlord having the right to give notice under Chapter 118A to come in and inspect the property, or to come in and make repairs in the property, to do things like that, I think you can still do that. However, I guess I would just think, practically speaking, until such time as you are in a position to be able to move forward, and that would be August 1. So this is, their question was with respect to a holdover tenant. The holdover tenants are covered. That's one tool in your toolbox, covered under 40.250. Those types of evictions may proceed August 1. So I would think you'd want to wait until closer to that time frame, so that if you are proceeding with your eviction, you would have your inspection, contemporaneous with that. But I don't know of anything that would prohibit you from utilizing your ability as a landlord to give 24-hour notice, as you're required to, and then inspect.
Judge, I would just ask if Michelle Newman from the AG's office can jump in, because she's been getting an onslaught. We've also spoken from day one. She's gotten an onslaught of questions or concerns from both tenants and landlords. Will you help clarify that for us? Because we've also from day one, the open house and in-person showing directive was a separate directive than the evictions, although they kind of seem to go together. But we've said, unless you have tenants' permission, once a property's in once a contract is in escrow, you have to get their permission to gain access. So will you clarify what the AG's office thinks about that?
Yes, I'd be happy to. And as a matter of fact, that question we often direct directly toward the real estate division, just because it's not specifically articulated in either Directive 8 or Directive 25. So usually, I mean, I completely, support everything that Judge Saragosa just said, but to be just very forthcoming in terms of how we filter that question in the Bureau of Consumer Protection, we are more apt to direct them to the real estate division, because we want the consumers, both the tenants and the landlords that call in, to get the most accurate information. And just because that kind of falls outside of the directives that that we are particularly enforcing, that's generally how we will answer that question.
And I know Mark was on last time, and he spoke about if something's an emergency, if it's a water heater or something like that, yes, then that's different than if you just need to do like a routine inspection.
Absolutely. And that, so Directive 8 and the guidance mentioned that corresponds to Directive 8 specifically states that the landlord needs to maintain the habitability of the dwelling unit. That obligation at no time went away, even if the tenant obviously is not paying rent. So that is something obviously the tenant would still need, the landlord would still need to file and follow the appropriate procedures listed in 118A in order to enter a tenant's unit, but that is a obligation that is still completely in place.
And we've got a lot of questions in the chat regarding entering into a property, whether the tenant's there or not there, repairs and whatnot. And so again, if we don't address them here more in our global statements, your individual questions will be answered via FAQs afterwards. And so we're talking about 2 more weeks in terms of this, the tenant, because as of July 31st, come August 1st, that directive, unless the Governor Sisolak changes or extends it, will allow the entrance into tenant occupied properties, but again, with proper notice. And so for the next 2 weeks, we still have to be very diligent and make sure that we are following that directive and not entering tenant occupied properties unless it's an emergency or the property's under contract and we give them a 24-hour notice for inspections and whatnot. Super, thank you for clarifying that, Michelle. And then I see that also Whitney has joined us as well. So welcome, Whitney, from the AG's office as well. Thank you for joining us this morning. And Tiffany, you've got another question, I believe, that you wanted to share with us.
Yes, thank you. So a question that Judge Saragosa and I have discussed a lot is, if a contract is on a month-to-month basis, can we give a 30-day contractual notice now?
So that's definitely a question. There's a little bit of interplay, as you all may know, that there is a statutory 30-day no-cause notice. And that 30-day no-cause notice is just one, again, of the tools in Chapter 40. But that is statutorily driven. Many times your lease agreement is just some of them have what I call a hard termination date. So, you know, July 1 to June 30, your lease is terminated. There's no notice required to the tenant at that point to tell them they got to get out. They know that because it's in their written lease agreement. It's done. Lease is over. So everybody expects the tenant's going to move out June 30th. If the tenant does not move out June 30th, then on July 1st, you give the 5-day holdover notice and proceed with your eviction. But at that point, they're already unlawfully detaining the property. That's unique to the other types of evictions that require a notice and then the tenant to do something during the notice time frame and fail to do it, and then they're unlawfully detaining the property. Your lease agreement essentially is the notice. But you also have leases that have a soft termination date. So it's July 1 to June 30th, but it will continue on a month-to-month basis thereafter unless one party or the other terminates the lease agreement by issuing a written notice. That is the type of notice that is contractually driven or driven by the lease agreement. The governor's directives don't discuss the landlord's or interfere with in any manner the landlord's contractual rights and responsibilities under a lease agreement contract. So in that sense, I think the landlord, can at any point give notice that they are terminating the lease agreement. Now you have to be cautious of that, because if you are terminating the lease agreement, you have to realize, one, you may not have, I guess at this point, we're here on July 14th. So if you gave that 30-day notice now, come August, you would be able to proceed with a holdover type of eviction. You want to make sure that you're not doing it in a retaliatory manner. There are still some prohibitions to, acting in retaliation. Those could be problematic, but I think that you absolutely can. You have many of these properties were intended to be up for sale. Some of this COVID-19 moratorium halted sales that were in the process. And to that extent, you can give that notice. If you give that notice and start accepting rent again, then, or you sign a new lease addendum promissory note for repayment, you just want to make sure that you're not giving mixed signals.
And then we talk about the process server. I know, again, it's something you and I have talked about a lot since last session. So if a landlord's just giving, or property manager is just giving a notice, like a contractual notice, not a Chapter 40 notice, do they need the process server, or can they give the notice themselves?
There is nothing that would dictate that other than what's written in the contract between the parties. So I would just defer to whatever the language says in the contract. And sometimes that contract will say it must be in writing, or it must be served by certified mail, or it must be served in a certain manner. I would rely upon what the contract says.
Thank you.
And that's a very good point, Judge Saragosa and Tiffany. Read your contracts. A lot of people are acting and not really reading the language in the contract. The contract's going to dictate how you proceed. And so we want to make sure that you're reading that language. Also, too, a lot of these rules are different if the tenant is in arrears, right? So we do need to make sure that if the tenant's current, we act a certain way, but if the tenant is in arrears, the directive also dictates how we can act and when those eviction proceedings can start as well. So please make sure that you're reading the information that NVR does put out, the FAQs, you're reading your contracts, and then also too, if and when the tenant and landlord enter into the lease amendment, that there are clauses and provisions in that lease amendment. I see a lot of questions in the chat that can be answered by just looking at that lease amendment and how you can act in the event the tenant defaults on the lease amendment. That the lease amendment actually has provisions in there that states how you can act if they were to default in that. So it's really important, again, that we're really reading our documents and understanding them and acting within those documents. So thank you. Christal, I know you have also fielded a lot of questions over the last several weeks, and so I know you've got one that's pretty popular that you'd like to share as well.
Yeah, and just going off what you said, the answer is included in the lease addendum, but I'll still throw it out there because I have been receiving this question. It is, if the landlord and tenant agree to enter into the lease addendum and promissory note discussed in the directive, and the tenant fails to make the first arrearage payment as set forth in the agreement, does the landlord have to wait until September 1st to evict?
I think
Judge,
that was what we
take that
discussed
one?
earlier. That was what we discussed at the beginning. I think we answered it. That's you have to wait for the 7-day, September 1st. But for if you breach the first arrearage payment, Judge Saragosa, do you want to talk about that? Isn't that what we already discussed?
5-day.
Yeah, the 5-day.
Under the 42516.
Yeah.
Eviction for failure to comply with the lease covenant or condition, and
Yes.
that may begin on August 1st.
Yes, correct.
Right. So you can't act on a non-payment of arrears unless you have that direct or that lease amendment signed. And then if they default on their payment plan, then you can issue the 5-day. And again, that's within, and I see that both Michelle and Whitney are shaking their head as well. That's within the lease amendment. The document has that provision in there. So we need to, again, make sure that we're acting and looking at that.
Hey, Molly, can I jump in and ask Michelle a question?
Sure.
Sorry. So I'm wondering if you or if the AG's office is setting up any type of webinar or particularly for the tenants to explain the addendum. Because I've, several times some property managers have entered into it. We've sent it over to them. Ask them, say, read this over, let us know if you have any questions. They fill it out, like their payments, and then come first. They are surprised that they still have to pay their rent along with these arrearages. And so we're coming back to them going, okay, how do you want to restructure it? And they're sort of shutting down. Like, it just feels overwhelming.
Okay. So we, at this point in time, have no intention of doing a webinar that's, from the AG's office. We are encouraging both, at times even landlords and tenants. We're continually taking complaints. For tenants in particular, we're encouraging them to go to legal aid organizations where they could sit down with a pro bono attorney and go over documentation such as the lease addendum so that they can have someone explain that. The other thing that we are encouraging everyone to look at, and this can be found on Nevada Health Response, is in addition to the actual document, there's a chart that was developed as well as some FAQ questions that are on the website that both tenants and landlords and anyone can review, and it kind of breaks down the dates, it breaks down the questions, to kind of get some more information so tenants and landlords can just become more educated about what the document is about and the procedure going forward. So, so to answer your question, we don't have any webinar that we are creating. However, we are always welcoming complaints from tenants and from landlords, and a lot of those complaints, especially now with the new directive, are actually coming kind of in the form of questions like, hey, is this acceptable, or can my landlord do this, or can I do this to my tenant? And we'll refer them out to either legal aid or answer them in the most appropriate manner.
I was just going to jump in though. I think that that's definitely an idea that we can bring back to our office. We don't have any plans as of now, but we can definitely mention that to them.
Great, thank you.
I would also encourage you to avoid trying to represent both the landlord and the tenant in the negotiation of this document, because it does put you in an awkward position to be able to try to explain the document to the tenant as if you're their legal advisor. So what we've recommended is we have a cadre of mediators available through the Neighborhood Justice Center. It's kind of a sidearm of the court. They are trained on this document. They understand the document. They understand the implications of both what you're giving up as a landlord, what you're receiving as a landlord, and for the tenant. And they can help mediate that agreement so that everyone understands. So I would encourage you to utilize that service with your tenants, especially if you find that your tenants are confused or don't understand. Then they have this kind of neutral party that's there to kind of explain it, as well as all of the resources at Legal Aid. Legal Aid has, a number of resources here and can answer those questions as well. One of the things that came up just a moment ago was, if you have this lease addendum promissory note and your tenant fails to make the first of however many arrearage payments are set up, and you're utilizing that 5-day notice that we've been talking about, it is a curative notice, as I stated before. So the cure is not to pay all the arrearages. The cure is to cure the payment that was missed. So if you have them set up on, say, $300 a month towards the arrearages, if they miss that $300 payment, they only have to make the $300 payment in order to avoid eviction. And once they've cured, then you don't proceed any further. So that, I think that answers one of the questions that was out there.
Yes. That was Tyler's
It's very
question.
helpful. And in regards to, and Judge Saragosa, in regards to your comment on the Neighborhood Justice Center and the resources there, I mean, time is going to be the essence for a lot of these workouts, and we are doing our best. And Danielle, to your question, I would highly recommend that you send out the FAQs that NVR published for both the tenants and the landlords that actually came out through the governor's directive. A lot of those will answer a lot of those questions, and they are documents that are self-read for either party to better understand what where they're at and what that lease amendment means. But the landlords are also going to want us to act swiftly too as property managers to help them understand and work through the arrearages. So there's a lot of great resources that we can send and that we can leverage. I think that they're going to be overwhelmed in the very near term. And so again, it's up to us as property managers to do our best to educate both the tenant and the landlord sides and help them work through it, but not obviously provide the legal advice.
I want to add just a couple of other things real quick. So one is in trying to mediate these agreements. So in terms of the court system and what we're seeing, I can tell you that last fiscal year, the state overall did 45,000 roughly evictions. That includes both evictions that are where no answer was filed and the case proceeded as what we down here call a straight eviction, or ones where an answer is filed and goes to hearing. So in total, 45,000. So the numbers that you all have been gathering, and I've gathered some from the apartment associations as well, and we had feedback on a survey that we put out from about 50,000 units, apartment units. They are an average of 11% in default. And it sounds like your numbers are about the same, right around that 10, 11% mark. But the projection is from a company that came in and did an evaluation of the rental units that are available in Clark County, that there are over 1 million rental units in Clark County. So if we're talking 10% of those, you're talking 100,000 evictions, which is more than double the evictions that the state did last year, and that's just in Clark County. Last year in Clark County, well, in the Las Vegas township alone, we did 33,000 of those statewide evictions. So we're talking the bulk are down here in Las Vegas. However, if we have to do that 10% of evictions, it will be overwhelming. Because of that, I can tell you that the Access to Justice Commission, in conjunction with Legal Aid and the Supreme Court of Nevada, has undertaken that they want to present a bill before the legislature, hopefully in a, they hopefully want to get the governor to address it in a special session before the 2021 session, to create a mandatory type mediation program for eviction actions, which would take place after the tenant answers a notice for non-payment of rent and possibly no cause notices that would stay your eviction action for up to 30 days. So I encourage you to work it out.
Well, that's certainly very good inside information. It brings me back to the 2008 crash, where there was mandatory mediation before foreclosures could happen.
Yes.
And it was longer than 30 days, right? That process took quite some time. You talk about 100,000 she'll work through in the near term.
And time is of the essence.
Yes.
So if your proceedings are stayed while you're trying to mediate, you're best served to try to mediate ahead of time and get ahead of it, like you've been trying all this time. But I want everyone to understand the volume that we're talking about and why everyone is so concerned about the overwhelming nature of what's going to happen. The other thing I want to, I guess, share is the good news out there. The city of Las Vegas has already opened and closed their rental assistance program for the millions of dollars that they had for rental assistance. The county has not yet opened it, but the county has roughly $30 million that they are going to put towards, and that's Clark County. I'm not sure about Washoe and the others. And Judge Haship may have some better information there. They are opening up theirs fair as soon as they can. They're working on some interactive apps and website stuff to open that up. So if you can get your tenants informed about these available funds, the more you can work with your tenant to let them know that these funds are available and they can apply for them, the quicker you might get your arrearage taken care of, and the quicker everybody can get back to kind of a status quo. So helping your tenants is going to be a big part of that.
Sorry, this is Teresa, if I can interrupt for just a moment. Nevada Realtors just had a meeting with the State Treasurer's Office about those relief programs, and we've invited them as soon as they are ready to give a similar webinar like this to our property managers as well, because for all of these relief programs, the idea is that these payments will go directly to the landlord, not through the tenant. So it behooves all property managers to help their landlords and the tenants get this help to get the money directly to the landlords. So we'll put out an invitation to everybody who's registered for this event for an event with the State Treasurer's Office where we can address that directly.
And it's going to come fast and furious because the city's program opened and closed within, I mean, a very short window of time, and the money was gone. So it's going to come really quickly once they're ready to open. I can't imagine it's going to be open for more than just a couple of days, to be honest, for them to take applications, and then it's going to be done.
And for the people that are on the commercial side that are on this call as well, Las Vegas Chamber has a link on their site as well for some relief for the commercial landlords too. I don't believe it's opened yet, but it's supposed to open in the next week or so, and that will go fast as well. So jump on the Las Vegas Chamber for the commercial relief funds. Excellent, good information. So it is 10:51, and so I'm going to race through a few more questions here. And again, I hope that we've answered a lot of your questions. Again, there's so many in the chat that hopefully the team is looking at. And if there's some that we should be addressing, please holler out.
And Molly, Judge, are you available to stay on a little bit longer with us?
I am.
Super.
Okay, so we'll keep going until you tell us when you have to exit. So
okay.
hopefully everybody else can stay on.
while we talk. So
Oh, good. Thank you so much.
sitting at my desk signing default judgments while we speak.
Molly, if I could just jump in. So a lot of the questions we're getting in the chat, and then we could go back to a lot of the frequently asked questions, a lot that we're getting have to do with the 30-day no cause, or if there's already been an answer filed, or if there hasn't, if somebody started an eviction prior to all this COVID. Can you just go into that a little bit, just because there's a lot of those types of questions?
Sure. So if you look at the directive, it's kind of broken down in sections, obviously, but in parts. And I'm kind of looking to the side at my screen. Sorry if I'm not looking at the camera. So section 5 of the directive addresses the stale and void notices. So if you served a notice on a tenant prior to March 30th of 2020, and the tenant has not filed an answer or an answering affidavit, then your notice is stale and you must start anew. You must either reinitiate your notice or initiate it for the first time, but that's the new. And all of that begins for everything that's not non-payment of rent or no cause begins August 1st for no cause notices, and for non-payment of rent, that begins September 1st. But if you look down to section 7 of the directive, that is talking about actions currently being adjudicated by the court. Those we have, well, the governor has defined in here, and we have interpreted it to mean all cases in summary evictions in which the tenant has filed an answering affidavit or an answer with the court. So if the tenant has filed an answer, it is deemed an action currently being adjudicated by the court, and the court will proceed with those August 1 for all of those that are not non-payment or no cause, and September 1 for the non-payment of rent and the no cause notices. Now here in Las Vegas Justice Court, and Judge Haship can speak as to what they're doing up north, we've already sent notices for those out, or we're in the process of doing that now. So we're not waiting until August 1st and then going to send you a notice to say, hey, we're putting your case on calendar today. We're already doing that. We're going to start now, send the notice out so that our calendar is already populated with a docket for August 1st, provided that's a judicial day. I haven't looked at a calendar, but that's the way we're proceeding with those. So if your tenant already filed an answer in Las Vegas, you should be getting a notice from the court saying your case is scheduled for a hearing.
Excellent. Thank you.
Judge Hashik, what are they doing up north?
He's not on. He got caught.
Okay, I'm sorry.
Tiffany, so thank you for bringing that up. And I know there's some other questions too in regards to not just holdover tenants, but noticing tenants. Most of the questions are regarding noticing tenants. When can we notice the tenant? If they occupy a property but haven't paid rent, when can we notice the tenant? If we've got a question that says if the lease expired in May, on May 31st, and they haven't paid rent since March 1st, when can we notify them for eviction?
Well, it depends upon the type of eviction. If you want to notify them of an eviction based on non-payment of rent, the magic date is September 1st. Right. If you want to notify them through a legal notice of an eviction on a different type, say a holdover, then the date is August 1st.
So if their lease expired May 31st and they have not paid, they have not entered into a month-to-month, they have not extended the lease, they are technically a holdover, and they can notify them August 1st.
And I say that with caution because I don't have the language of the lease in front of me.
Correct.
If your lease said your lease terminates on May 31st, period, then that would be accurate. If your lease says the lease terminates on May 31st, unless one party or the other gives 30 days notice or 60 days notice of termination, and you have not given that termination letter yet, then you have not complied with your contract, and you'll need to comply with your contract first. Otherwise, they're in a month-to-month situation now, and your lease did not expire on May 31st.
Again,
so read the contract.
Back to reading the contract, super important, because that is what the judges are going to read if this gets in front of them. And so you want to make sure that you've read that contract before they do and you're acting accordingly. One of the questions we're getting a lot of, and I've received a lot since we released it, is whether or not the promissory note and the lease addendum is a mandatory document, that has to be used when either working through the arrearages or moving forward on how we're going to address those arrearages. So is that a mandatory document? The answer is no, it's not a mandatory document. Because you can use any document you want, just like all of our leases are different. But we highly, highly encourage you to look at that document and use that document. The AG's office has reviewed it. Legal aid has reviewed it. The judges have reviewed it. We've reviewed it on our PAG. Your state attorneys have reviewed it. It is a document that we all agree. And again, I just mentioned a lot of people, and you can imagine how much energy has gone into getting all of us to agree that that really is a very good document to use moving forward. But it is certainly not a mandatory document that you need to use in working out the arrearages. But it's a very good document, and it provides both the tenant and the landlord with good provisions and good rights.
And Molly, one quick thing that I want to add into that is, and I'm just referring to section 1 of the most recent of Directive 25, where, in support of what you just said, where it does use the terms that that landlords and tenants are strongly encouraged to use the lease addendum and promissory note. But in that second or third sentence, it also explicitly says that entering into the lease addendum and promissory note is voluntary. And it says that right in the directive.
And it's in the FAQ as well that you would send over to your landlord and tenants. So thank you, Michelle, for clarifying that.
Yeah, so I have a question actually along those lines. Is we do get a lot of questions into the legal information line about what is considered coercing a tenant. So when do our property managers cross over into that line where their actions as they're engaging with their tenants during this time become coercive?
I don't think there's a definition for that, and nor can I give, advisory opinions or on hypotheticals or the like. I mean, that one, from my judicial canons, I can't do that. But two, I don't think there's not a black and white definition of that would be something you could recite. I mean, I could pull out my Black's Law Dictionary and read you the definition of coercion, and it can be applied in a general sense, but it's kind of one of those, you know it when you see it, because you have to look at all of the individual facts and circumstances that went into the discussions, what was going on. I mean, if they're left with no choice. So that, hold on one moment.
I think we could all agree that as long as we are explaining the best we can what the directive has in place and what we can and can't do without being heavy-handed. I mean, once we start making somebody feel uncomfortable about a position, they are going to say they were coerced. I mean, we all know that we've all been in positions where you feel like you're being backed into a corner and you have to do something. And if that's their position, then that's going to be a tough place to be in. So the best thing we can do is mediate between the two based on the letter of the contract and what the directive is stipulating, as well as the CARES Act, obviously through July 24th with the forbearance pieces of that. Judge Saragosa, you went dark. I don't know if you're off or on.
I hear pages turning. I think she's looking in the dictionary, and I want to clarify that as well. As I think the sense from the members that I'm getting is that they just want to make sure that they can even approach the tenants and make sure that even asking of the question to cooperate, whether it is for the promissory note lease addendum, that wouldn't be construed as coercion, because I think they're very scared, and they're even scared to even broach the question. And so just I think clarifying that so that property managers know that, if it is the feeling of being backed in a corner, just, having that clarified so that they don't feel scared to kind of enter into this or approach
And maybe
it.
we can hear from the Attorney General's office. If one of you can maybe tell us some of the complaints you've seen and how those are being handled. Does Michelle or Whitney want to address that while we're waiting for the judge to get back on?
All that I can say is kind of reiterate what Judge Saragosa said, that it's a case-by-case basis. We handle each complaint with care, and we really weigh all the specific facts in each case to determine whether coercion exists in that case.
I'll jump in also to say one of the things that we've done at our company is educate. Again, I go back to NVR's FAQs, the FAQs for how this applies to a tenant, how it applies to a landlord. They're there. I would highly recommend that you send those over to the tenants and to the landlords so that they can help educate themselves as well. But it indicates scenarios and what can and can't happen. And our best thing that we can do is educate. Once we educate and we can act within the corners of the directive, it's not coercion, it's simply informing and doing the best we can for all parties. But if you're not sending that information over and you're not allowing the clients to educate themselves by providing that document that you did not author, right, that was done by somebody else of authority, it's a super start. It's a great start to open those communications, but the communications have to start, and they legally can start now. Let me ask another question. Oh, is Judge Saragosa off? I don't see her back on yet.
But Molly, I think a good question maybe for the AG's office. Sandra Wakefield just posted the lease addendum is specific for COVID. What if the tenant is not affected by COVID? Is there a document that can be used to stay in compliance for repayment? So, what do you recommend as far as that goes?
Can she clarify the question? Does she mean that you had to have had the reason for defaulting on the rent be due because of COVID?
Yeah, I think it specifically says that it's COVID related, but what if the tenant just has failed to make payments because of the eviction moratorium?
Yeah, just to be clear, the addendum can be used regardless of why the tenant went into default on their rent. We just mean that it's because COVID started this entire pandemic. It caused the emergency situation that we're in, and that's what we mean by COVID related. But it does not have to be a result of COVID related things, and it can be used in any situation.
Thank you.
Like an act of God situation.
Right. Any arrearage, let's just say, can be used. One of the questions that's super popular for the residential side of the business is, and Tiffany, you can take this one. Can we evict tenants because a landlord wants to sell the house? When can we do that?
So I think that all goes along with what legislation was passed last session. What we discussed last session was the lease runs with the land, and so as long as you have absent another agreement otherwise. So if the owner and the tenant agree that they're going to terminate the lease before they want to sell, that's one thing. If the lease is still in place, then it runs with the land, and it would follow all of those same procedures we've been talking about as far as the August 1st and September 1st. If they fail to make a payment on rent, or if they're a holdover, then August 1st they would kick in for the holdover, September 1st for non-payment of rent. But no, you can't say you're going to sell the house if the tenant still has a valid lease.
Super. Thank you. Judge Saragosa, are you back on?
Working on it.
We love Zoom and hate Zoom all at the same time.
Okay, can you hear me now?
We can.
You won't be able to see me because I am not supplied a camera on my county computer and my phone died. So, but you can hear me.
Absolutely. So did you find that page in the dictionary?
I did. So coercion is very generically explained, as I anticipated. It is to be compelled to compliance, constrained to obedience, or submission in a vigorous or forcible manner. It can be actual, direct, or positive, as where physical force is used to compel an act against one's will or implied, legal or constructive, as where one party is constrained by subjugation to the other to do what his free will would otherwise refuse. See how helpful that was?
Very broad.
Yeah, it is super broad. That's the problem. It's very, very fact driven. That's really all I can say is, so every case is going to be different looking at the individual facts of what happened.
Super. Well, are there any other questions that we should address right now? Anything that's popping off the screen? I know there's some that are on the screen now, and there was an FAQ that was released just yesterday regarding squatters. That has never been part of the directive, and I know, Judge, you can also speak to this as well, that you've been moving forward with evictions for squatters. That's not part of the directive.
Agreed, it's not. We are processing them and have been throughout the pandemic and the moratorium. But just be aware that you have to meet the definition of a squatter, and squatter is just a term that we use in layman's terms, but legally it is someone who meets the definition of either an unlawful entry or a forcible entry or a forcible detainer. So it is someone who breaks into the home. It is not, and what I see a lot of, it is not, you had a tenant and you thought your tenant moved out, but your tenant left friends behind or allowed their nephew to move in and you didn't authorize it. It's not unauthorized in that sense. If your tenant is living there and your tenant authorized someone else to be there and you didn't know about it, they still arrived in possession of those premises with some level of authority from the person who was in possession, your tenant. That is not the definition of a squatter, and you will not get a removal action that way. That must go through the eviction process.
Judge Saragosa, last time we also defined what a tenant at will is, and that question just popped up. Will you also tell everybody what a tenant at will is?
Yes. Again, this is one that does not have a definition in the Nevada revised statutes, but coming from our, legal world, case law, common law definitions, a tenant at will is someone who is given a temporary authority to reside in the premises. That could be somebody who's just couch surfing for a couple of weeks. It could be, you authorized your grandchild to come and stay in your home for a couple of weeks. It's a voluntary presence where there's no periodic payment of rent of any kind, where there's no specific time frame for how long they can stay there or not stay there, or it's just a short time frame, short duration, but it's kind of a loose agreement where there's no real rental obligation or other obligation in mind. So they might pay rent periodically just as they feel like it, but there's no agreement that they have to pay in any specific periodic time. I will give a couple of examples that I've just given. The other more common example would be a boyfriend-girlfriend situation where you're dating, you invite your girlfriend to come move in with you. She does. It's anticipated that she'll be there for the duration of the relationship, however long that may be, but she doesn't pay rent. There's no rental agreement. She's really just a tenant at will.
Hope that clarifies it. So be careful who you allow to couch surf. One of the really popular questions as well that we have is the 45-day notice to increase rent, and the other notices. Does that need to be done by a process server, or can that just be done via a memorandum, a letter, an email?
Mm-hmm. The 45-day notice to increase rent comes from Chapter 118A, and under Chapter 118A, I personally believe this was an inadvertent application of the statutory change in service, because what it says under 118A 190 is that all written notices to the tenant prescribed by this chapter, meaning chapter 118A, shall be served in the manner provided by NRS 40.280, which is the process server and or constable service. So technically, under the statute, it must be served in that same manner. I don't know that that was anticipated when that change happened, or it was even recognized or discussed at the legislative session, but that is what it says.
Okay, that clarifies things. And what if a tenant refuses to enter into a lease addendum? Are their phase timelines the same?
I assume they're meaning the phase timelines in the governor's directive.
Correct.
And I would cite back to what Michelle stated earlier in section, I think it's 1, where it specifically says it's voluntary. It's voluntary for the landlord and it's voluntary for the tenant. So if the tenant is not interested in coming to an agreement or signing a lease addendum or promissory note, then the same timelines that are in the governor's directive applies. So you cannot proceed for non-payment of rent until September 1. And you can proceed on all other types August 1, except for no cause, sorry. No cause is September 1 as well.
Okay, so that helps a lot. So no cause and non-payment of rent is September 1, and everything else is August 1. And then one of the other common questions is, can the property manager ask the tenant for documentation as to why they can't pay rent?
I guess it would depend upon what they're trying to ask for. You can ask. I don't think the tenant is under necessary an obligation to provide it. The lease agreement or the lease addendum promissory note does not require, and this was heavily discussed in the conversations with the Attorney General and the various groups that were involved. There were some that absolutely wanted a, what's the word I'm searching for?
Eligibility.
Thank you. That is exactly the word I'm looking for. There was several people involved in that conversation wanted some sort of eligibility criteria in order for the landlord to be required to enter into this lease addendum promissory note, and others did not. And so that was the topic of much discussion between the various groups. And at the end of the day, the Attorney General who assisted in the drafting of this did not put any eligibility criteria in here, and instead gave the incentive for the landlord to enter into the agreement because they got that 30-day head start, if you will, if there was a non-payment. You get the 30-day head start, and by that I mean your phase of the evictions that begin August 1 for for a violation of a lease covenant or condition is authorized a month earlier than the non-payment. So you can ask for it. I don't know that there's any obligation to give it. And certainly it would not be wise to be asking someone for medical documentation, things like that. That would, you know, there may be other Privacy Act restrictions, and there may be
fair housing, disability,
violations.
all of it applies.
Yeah.
HIPAA, fair housing. We've got to be very careful, team, that you're not asking for information that is protected under fair housing or HIPAA.
Or Privacy Act.
Yeah, or Privacy Act. And so be very careful that that doesn't happen. There's provisions, again, in the addendum that allows you to act without having to dive that deep. And going back to coercion, that could be overlying on that as well. And Whitney and Michelle are both shaking their head too. So we want to make sure that we're being very careful and being fair to all parties. So
well,
it is.
Molly, I think also when you go in front of the judge, I mean, that's what Judge Saragosa does day in and day out. She feels out the situation. She understands where the parties are coming. She asks the questions that need to be asked. And I think all of that was contemplated in creating these documents in this directive, is they're still going to go in front of a judge, and a judge is still going to ask these questions and make these determinations.
Right.
There's a question on here that says something about if your lease agreement has some clause in it that talks about someone staying in the property for more than 14 days in a calendar year has to apply. I guess I'm not really familiar with that particular term in a lease agreement, but and I'm not sure what it means by even if. Does anyone have a better understanding of what that question is trying to get at?
I think what she's saying is, if a lot of times the leases will say if somebody's staying in a property more than a certain number of days, then they have to be a tenant.
Right.
So it goes back to what type of tenant is somebody, and they're not a tenant if they're just sleeping on your couch. That question came after your talk about the couch surfing.
Okay, so I would just note to clarify that the tenant at will is a relationship between a landlord at will and a tenant at will. It's not between tenant and their occupant or their person who stays more than 14 days in a year. So, for example, you as the landlord can only evict your tenant. Otherwise, so I see what she's trying to ask here, and this is what I want to clarify. So if you go to Chapter 40, and yet I'll use my analogy to the tools in your toolbox again. So under Chapter 40, 40.2514 outlines a number of things that can be an unlawful detainer. One of those is either assigning or subletting the leased property contrary to the covenants of the lease. So if your tenant is either assigning or subletting the property to someone else, then you may use this 3-day notice to evict. But you have to know what an assignment is and what a sublet is in order to define that. That is generally not an assignment means the tenant takes all of their rights under the lease and tries to give it to somebody else. They're not involved anymore. They're not there anymore. They're not in the property anymore. They've given all of their rights under the lease to somebody else and basically moved on. And that new tenant is stepping into the shoes of the old tenant and now paying rent to the landlord. If the landlord says that's not authorized, you can't do that, then you would not evict the new person. You evict your tenant who violated the terms of your contract under 40.2514, even though your tenant's not there, because everybody underneath of the tenant goes along with them. But your caption would be landlord versus tenant, not landlord versus new guy who moved in. A sublet is more along the lines of what I call like the college summer. So a college student rents an apartment for a year because the landlord makes them sign a year's lease, but they know they're not going to be there over the summer because they're going home, and they get somebody else to take their place for 3 months. That's more of a sublet. Again, if that situation arises, the landlord evicts the tenant, the student, because the tenant is the one who has the contractual provision that prohibited them from subletting. Now, you also have the 40.2516 5-day notice for failing to perform a covenant or condition or covenant of the lease. If your lease agreement says you are not authorized to bring all these strangers into the property. I, as the owner, as the property manager, I need to know who's there. I need to know, who's responsible for taking care of it. And you just can't move people in. So if they stay more than 14 days a year, you have to apply and they have to be approved to live there. And you as the landlord find out that your tenant has moved in their boyfriend and you didn't know about it and you didn't approve it and they've been there for more than 14 days. Your remedy as the landlord is not a 5-day tenant at will. It's violation of a lease covenant and condition, because your lease, if you read your lease, says you can't do this, and they did this. So you're going to use a 5-day notice. I hope that clarifies that.
Yes, thank you. And I have 2 quick questions, and then we're going to wrap up. One is, can we do an increase of rent August 15th to take effect October 1st? And I think the short answer is yes, as long as it's done properly.
Agreed.
Okay. And the last one that comes up a lot, and we touched on this a little bit, if an eviction was granted prior to the moratorium, but the constable just did not do the lockout, what does the landlord need to do to get the order reauthorized so the constable can complete the lockout?
Okay, so that's one. I know there were a couple that fell in that area where the court had already issued the eviction order. Under our local rules, the eviction orders are only good for 30 days. So if it wasn't acted on by the constable, I think that's going to have to be done by some sort of motion to the court. There's not an easy answer to that because that's such a unique situation. So if you did fall in that weird category, then I would suggest you file a motion with your court, whatever it is, to reopen the case and reissue a new eviction order. That would be my recommendation.
Okay, super.
And I want to go back for 1 second when I jumped too quickly and said, I agree, you can serve that 45-day notice to increase rent, because there's a caveat to that. Again, if you signed a lease that is good, let's say January 1 of 2020 to December 31 of 2020, no, you may not increase rent during that time frame because you have a contract that says your lease or your rental amount is X dollars until December 31st. If you're on a month-to-month basis, then yes, you can use that 45-day notice to increase. And otherwise, if your lease expires December 31st, then you would wait until, I guess, what, November 15th to serve that 45-day notice.
Yeah, you've got to be 45 days from expiration or on a month-to-month.
Yeah.
Yeah, thanks for the clarity, for sure. Super. Well, wow, there was a lot of information, and we're going to be doing this again because the chat does not stop. I said we had 2 more questions, and I think 5 more just came in. So we'll do our best to answer those questions. And again, I encourage you to reach out to NVR's Legal. We've got both Christal and Tiffany on the call, as well as the AG's office. Most of the FAQs came from them that we worked together on. And so push out that information, get your head around it. A lot of this is going to hopefully be lifted here in the next 2 weeks to 45 days. And so we'll go back to a little bit of normalcy unless, again, the governor changes the directive, which could always happen. And so we just want to make sure that we've got our eyes open and our ears open as well, and continue to stay informed. Please make sure you're reading NVR's emails that come out on a pretty regular basis, because it's chocked full of pertinent information that's very timely. And I know Teresa had a few more things to add as well. You're muted.
That's what I get for multitasking. I was trying to respond to some chats as well. A lot of what you said was what I was going to cover. There are FAQs that we have done that are on our website. Very importantly, I know a lot of the questions that people are asking are answered by the FAQs that were created by the Attorney General's office. Those are fabulous documents. There's a chart that tells exactly what kind of eviction you can do when, depending on the circumstances. A lot of resources on our Nevada Realtors website. That's been posted several times in the chat. And we'll get these out to you. There's just been a lot of information today. We'll respond with the resources in an email to the people who attended this webinar. Also, we do have the recording from last week. We had a lot of repeat questions from last week's webinar. That's on the YouTube channel and on our website as well. And the recording for today, of course, will be posted. I wanted to let people know I was in discussions during all of the meeting today on scheduling with the Treasurer's Office about the relief programs. There are many relief programs going on. I don't know if there is one clearinghouse of what relief programs exist, but that's something that we will work on and try to provide that as a resource as well. But the Treasurer's Office resources, those will be big, they will go fast. There's a lot of information behind those that we will help you get the answers to as well. And everything with the FAQs from the AG's office and the lease addendum, those forms are also in our e-news from July 29th. That's also been posted a couple times as well. And I just want to thank all of the panelists. Molly, you did a great job moderating, and we would not be able to do this without Judge Saragosa. We really, really, truly appreciate your time. And of course, the AG's office, you guys have been great to work with. We couldn't have done all this without you as well. So I just wanted to thank everybody that's on the call, and look forward to all these resources. Look and find those resources. And of course, the legal information line is open, info line at nvrealtors.org. That's been posted a couple times as well. Thank you, Molly.
Excellent. Thank you, everybody, for your time. I know we went over, but I know it was very, very important. Hopefully we answered your questions. If not, keep sending them. And until then, stay healthy. Thank you.